Getting a divorce in Washington is actually simpler than you might think. The filing spouse must be a resident of or stationed in Washington. Divorce may be filed in any county where the petitioner or respondent resides. The court will not act on the petition until 90 days after the filing and service of summons. Once the residency requirement is completed, a legal grounds for a divorce must be established. Washington only recognizes irretrievable breakdown of the marriage as a valid grounds for divorce. Washington requires a parenting plan for child custody. Joint or sole custody is determined by the best interest of the child. Every divorce with children must include a proposed parenting plan. The parents may then agree on that parenting plan. The plan should consider dispute resolution, a residential schedule for the child, and allocation of decision-making authority relating to the child. In determining decision-making authority, considerations are if both parents agreed to mutual decision-making, the existence of any physical or sexual child or spouse abuse, neglect, or abandonment, the history of participation of each parent in the decision-making process, whether the parents have demonstrated an ability and desire to cooperate in the decision-making process, and the parents' geographical proximity to each other to the extent that it would affect their ability to make timely mutual decisions. In determining residency for the child, considerations are the strength, nature, and stability of the child's relationship with each parent, including the parent's performance of daily parental functions, any spouse or child abuse, neglect, or substance abuse, the history of participation of each parent in child rearing, the wishes of the parents, the wishes of the child, if of sufficient age and maturity to express an opinion, the child's relationship with siblings and other significant family members, and any agreement between the parties. The first factor is weighed most heavily. Equal time alternating residency is only ordered if there is no child or spouse abuse, neglect, abandonment, or substance abuse, the parents have agreed to such provisions, there is a history of shared parenting and cooperation, the parents are available to each other, especially in terms of geographic location, and the provisions are in the best interests of the child. The court may investigate parenting arrangements for the child. Either parent may be ordered to pay child support. Marital misconduct is not considered, but all other relevant matters are. Official child support guidelines and worksheets are available from the Washington Department of Social and Health Services and the court clerk. The official guidelines are presumed correct unless the amount is unjust or inappropriate under the circumstances. Mandatory wage assignments may be required if child support payments are overdue 15 days. Payments may require payment through the Washington State Support Registry or directly to the parent if an approved payment plan is accepted by the court. The court may require either parent to provide health insurance. Washington is a community property state. Each spouse retains his or her separate property consisting of all property acquired prior to marriage, any gifts or inheritances, and any increase in value of the separate property. Quasi-community property is property acquired while a spouse resides outside of Washington but would have been community property if they were living in Washington. Quasi-community property is divided as if it was community property. The court divides the community property, consisting of all other property acquired during the marriage, equally or equitably after considering the nature and extent of each spouse's separate property, the economic circumstances of each spouse at the time the division of property is to become effective, the length of the marriage, the nature and extent of community property, and the desirability of awarding the family home and the right of occupancy for reasonable periods to the custodial parent if there are minor children. Either spouse may be ordered to pay maintenance to the other spouse. Marital misconduct is not considered. Instead, considered are the time necessary to acquire sufficient education and training to enable the spouse to find appropriate employment and that spouse's future earning capacity, the standard of living established during the marriage, the duration of the marriage, the ability of the spouse from whom support is sought to meet his or her needs while meeting those of the spouse seeking support, the financial resources of the spouse seeking maintenance, including separate or community property apportioned to such spouse and such spouse's ability to meet his or her needs independently, the needs and obligations of each spouse, the age of the spouses, the physical and emotional conditions of the spouses, and any child support responsibilities for a child living with the parent. Maintenance may require payment through the court clerk or the Washington State Support Registry if child support payments are also being made. Upon request of either spouse or by the court, the spouses may be referred to counseling services of their choice. A request from the counseling service must be made within 60 days of the referral. Contested issues regarding custody or visitation will be referred to mediation. Settlement conferences may be mandatory if there are contested issues. Visit us today at www.mydivorcepapers.com and click on Washington at the bottom of the page. Let mydivorcepapers.com help you file for divorce today.